Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. Alhamdulillahi rabbil alamin wa bihi nasta'in wassalatu wassalam ala sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. Firman Allah SWT dalam surah An-Nisa ayat ke-32. A'udzubillahi minasyaitanirrajim wa la tatamannaw ma faddalallahu bihi ba'dakum ala ba' للرجال نصيب مما اكتسبوا وللنساء نصيب مما اكتسبنا واسألوا الله من فضله إن الله كان بكل شيء عليما. Dan janganlah kamu terlalu mengharapkan limpah kurnia yang Allah Ta'ala berikan kepada sebahagian daripada kamu melebihi sebahagian yang lain tentang harta benda, ilmu pengetahuan atau pangkat kebesaran. Kerana telah tetap orang-orang lelaki ada bahagian daripada apa yang mereka usahakan dan orang-orang perempuan pula ada bahagian daripada apa yang mereka usahakan. Maka berusahalah kamu dan pohonkanlah kepada Allah akan limpah kurnianya. Sesungguhnya Allah sentiasa mengetahui akan tiap-tiap sesuatu. Yang amat berhormat Tuan Haji Muhammad Sanusi bin Mat Nur, Menteri Besar Kedah Darul Aman. Yang berhormat Senata Datuk Dr. Haji Zulkifli bin Muhammad Al-Bakri, Menteri di Jabatan Perdana Menteri Hal Ehwal Agama. Yang Amat Arif Datuk Syekh Abdul Rahman bin Haji Abdullah, Ketua Hakim Syarie Jabatan Kehakiman Syariah Negeri Kedah. Yang berusaha Profesor Syamsul Jamili bin Yop, Naib Chancellor UniSHAMS. Tuan-tuan dan puan-puan yang dirahmati Allah sekalian. Alhamdulillah, setinggi-tinggi kesyukuran dirafakkan kepada Allah SWT kerana dengan izin dan inayahnya kita dapat bersama dalam persidangan antarabangsa dalam isu-isu berkaitan harta sepencarian ICJAP 2020. Terlebih dahulu saya ingin mengucapkan terima kasih kepada pihak penganjur Universiti Islam Antarabangsa Sultan Abdul Halim Muazzam Shah UniSHAMS kerana telah sudi untuk menjemput saya untuk menyampaikan ucapan dalam persidangan antarabangsa ini yang bertemakan harta sepencarian antara kemaslahatan dan kemudaratan melalui dimensi syariah dan undang-undang. Secara peribadi, saya berasa bangga dan bertepatan dengan masa apabila pihak penganjur memilih tajuk berkaitan harta sepencarian pada persidangan ini. Setelah sekian lama tajuk yang serupa dianjurkan oleh mana-mana institusi pengajian tinggi. Saya juga difahamkan banyak kertas kerja yang akan dibentangkan pada persidangan ini meliputi pelbagai aspek berkaitan harta sepencarian oleh para pembentang dari dalam dan luar negara. Syabas dan tahniah saya ucapkan kepada pihak penganjur. Ladies and gentlemen who are blessed by Allah SWT, harta sepencarian or jointly acquired property basically refers to the property acquired by the joint effort of the husband and wife during their marriage. Harta sepencarian is also known by many names such as carian laki bini, pencarian, gono gimba, harta syarukat, harta usaha sama, harta suarang dan harta laki bini. Muslim scholars of the past did not provide a specific definition of harta sepencarian in their books. This may be due to the tradition in their time that is, it is only the husband who goes out to work to make a living and to accumulate wealth, while the wife is at home to manage the children and the household. As a result, the question of harta sepencarian did not occur. This is different from the customs of the Malays in this archipelago, where the typical population was farmers. Husbands and wives work together to farm and cultivate their land. When they are separated, the property or land they work for will be split between them. Since time immemorial, therefore, the jointly acquired property has been synonymous and affiliated with Malay customs practiced in the culture of this region. Therefore, the first key to all laws relating to harta sepencarian in Malaysia lies in the history. According to lead Professor Ahmad Ibrahim, Jointly acquired property originates from the Pepatih custom practiced in Negeri Sembilan and the Nanning district of Malacca since a long time ago. This tradition gives the wife the right to claim part of the property of her husband after the divorce. This tradition is practiced with the aim of preserving the welfare of women and their survival after divorce. This is a maslahah and wisdom behind the practice of jointly acquired property. As a matter of fact, harta sepencarian claims have long existed in our legal history. Among the longest cases ever recorded is the case of Tijah versus Mat Ali, which took place in Penang in 1884. British colonial officer E.N. Taylor in 1937 reported the case. In this case, the parties were husband and wife and lived in Province Wellesley, Penang. They had jointly rented lands and planted paddy and made nipah sugar. From time to time, they had sold the paddy and sugar, and the husband received the proceeds, part of which was used for their daily expenses. The husband retained the balance for himself. After their divorce, the wife sued for $15, being a half share of this balance, as the joint earnings of husband and wife. The trial judge approved the wife's claim in regards to jointly acquired property. E.N. Taylor, while giving his commentaries to the cases of Ri Elang 1927, Ri Kulub Degor 1928, and Lebar versus Niat 1920, which took place in Perak, states thus, he said, "We are concerned, therefore, not with Muhammadan law, as expounded by Arabic jurists, but with a curious combination of such parts of the ancient traditional or customary law of the Malays as have been preserved and such parts of the Muhammadan law as have been superimposed and which is shortly but not very accurately described as Muhammadan law as varied by local custom. If she did not work on the land, she receives a smaller share, perhaps 1/3. If a man of this class earns a salary, example as a government servant, and property is bought out of his earnings, the wife's share is 1/3. If the marriage is dissolved by death, the same rule applies. The survivor takes a half or a third, as the case may be. At this juncture, a detailed review of the cases identified by E.N. Taylor, including a well-known case, among that is Rama versus Latun 1927, clearly demonstrates that the practice of Islamic law, in addition to Malay customs, is widespread in all Malaya states. This includes the practice of harta sepencarian. This practice has developed into a rule and has formed part of Malaysian local legislation. In addition, there are also plenty of thoughts and views of local scholars justifying the recognition of jointly acquired property in Islamic law based on the concept law of Syariah, or purely local custom recognizable by Syariah, or based on compensation or ujrah upah. This justification is important because the concept and practice of jointly acquired property did not exist in the early days of Islam or during the reign of the Khulafa ar-Rashidin. Therefore, we will find that this discussion of jointly acquired property is unlikely to be found in the books of fiqh written by scholars from the Middle East. As I mentioned earlier, the concept of harta sepencarian is nowhere to be found in Muslim scholarly literature. There are nevertheless several writings of past Muslim scholars who have addressed the question of jointly acquired property indirectly with limited scope under the title of Mata' al-Bayt, household appliances, Mal az-Zawjain, property of husband and wife, or mata' az-zawjain, husband and wife appliances. Ibn As-Simnani in his book Rawdatul Qudat wa Tariq an-Najah lists 7 opinions of the fuqaha on the division of household appliances in the event of a conflict between husband and wife. Yet, the concept of jointly acquired property in Malay practice is broader and not just limited to household appliances. Ladies and gentlemen, brothers and sisters who are blessed by Allah SWT, after the independence, harta sepencarian has formed part of local legislation. Although since the 1970s, many cases had been decided in the Qadi courts, there were still cases of jointly acquired property decided in the civil courts. Cases like Muhammad versus Commissioner of Lands and Mines Terengganu, 1968, Roberts Elias Kamaruzaman versus Umi Kalsum, 1966, Boto Taha versus Ja'far Muhammad, 1985, are among the Muslim jointly acquired property cases presided over and decided by the civil court judges. After the amendment of Article 121 of the Federal Constitution in 1988, jointly acquired property or harta sepencarian has become a matter exclusively to be decided in the Syariah court. Alhamdulillah. Provisions related to jointly acquired property have been codified into Islamic family law in Malaysia since the 1980s. Then in 2002, efforts have been made by JKSM to revise and uniform all Sharia laws in Malaysia. And this task has been continuing up to this date. For that reason, we may find the provisions relating to harta sepencarian is more or less same in all states in Malaysia. In terms of practice in the Sharia courts, jointly acquired property claims can be made in 3 circumstances, namely, after divorce, after the death of the spouse, and finally when approving polygamy applications or polygamy registrations by the court. Section 122, Clause 2 of the Islamic Family Law Kedah Darul Aman Enactment 2008, for instance, clearly stipulates that in deciding jointly acquired property cases, the court shall take into account, among others, the extent of the parties' contribution, secondly, any debt owed by one of the parties which has been made for their mutual benefit, and finally, the needs of the minor children from the marriage, if any. Here again, brothers and sisters, ladies and gentlemen, we can see the wisdom or maslahah that needs to be preserved. The maslahah here does not confine to the welfare of the separated husband and wife only, but it extends to welfare of the affected children as a result of divorce. Apart from this, the court may also make an order relating to jointly acquired property upon granting approval for polygamy or ordering the registration of polygamous marriages based on Section 23, Clause 10 of the same enactment. This is to ensure that the current wife rights and well-being are assured and not compromised, as well as to prevent any subsequent conflicts between the wives. Meanwhile, there is no clear provision in the Islamic family law enactment in Malaysia with regard to harta sepencarian after the death of a spouse. Nevertheless, there are cases in this category that were brought and decided in the Sharia courts based on Sharia law. Among them, Bunga binti Ibrahim versus Ila, alias Zila binti Abdullah and Aziz in 1994, Hajah Saudah versus Hanafi, Sami' binti Mamad versus Siti Zubaidah binti Yasim, Hafsah binti Sa'ad versus Suryanata Baharum and Syarie Samad, 2004, Hajalijah binti Jamal versus Fatimah binti Madiyah, 1981, and several other cases. For the purpose of uniformity of this matter, the Department of Sharia and Judiciary of Malaysia, JKSM, has issued Practice Direction number 5 of 2003, which states that the claim for harta sepencarian can be made either during the divorce application or after the death of the spouse. In order to further strengthen the position of jointly acquired property after death, several states have issued a fatwa on this subject. Among the fatwas issued is by the state of Selangor, which explains that in the event of death, the surviving party can apply for a declaration of jointly acquired property before the property becomes the estate of the deceased. In the case of Muhammad Razali bin Ibrahim versus Adnan bin Shafi'i and 5 others, the Selangor Sharia Court of Appeal, in its judgment on the 27 August 2019, clearly stated that the jurisdiction of the Sharia High Court to hear and decide on jointly acquired property claims as a result of divorce is in accordance with Nassul Kitab by Al-Imam Al-Shafi'i, which he states, أخبرنا الربيع بن سليمان قال الشافعي رحمه الله تعالى إذا اختلف الرجل والمرأة في متاع البيت الذي هما فيه ساكنان وقد افترقا أو لم يفترقا أو مات أحدهما فاختلف ورثتهما أو ورثة أحدهما بعد موته فذلك كله سواء. Ar-Rabi' bin Sulaiman narrated to us, Imam Shafi'i radiallahu anhu rahimahullah said, when there is a dispute between a man and a woman over the household appliances in a house they live in, whether they are separated or not, or both are dead, or one of them is dead, in which the heirs dispute the matter after the death, then the position of the settlement is the same in all circumstances. Ladies and gentlemen, brothers and sisters who are blessed by Allah subhanahu wa ta'ala, and Ka'b bin Iyad قال سمعت النبي صلى الله عليه وسلم يقول إن لكل أمة فتنة وفتنة أمتي المال قال أبو عيسى هذا حديث حسن. Ka'b bin Iyad said, I heard the Prophet sallallahu alaihi wasallam, peace and blessings be upon him, said, verily every nation has a trial, and the trial of my nation is wealth. This can be found in Sunan Tirmizi, hadith number 2258. Brothers and sisters, ladies and gentlemen, disputes related to jointly acquired property are amongst the most complicated, difficult and challenging matters to be dealt with by the Sharia court. This complexity increases when each case involves a large amount of property and different types of property. In addition, cases related to jointly acquired property are also increasing day by day. I will illustrate this by bringing some statistics to your attention. For the period of 2010 to 2019, a total of for the period of 2010 to 2019, a total of 14,114 of jointly acquired property cases have been registered in Sharia courts in Malaysia. The breakdown of the number of cases for the last 5 years is as follows. 2015, 1,439 cases. 2016, 1,580 cases. 217, 1,553 cases. 2018, 1,630 cases. And 2019, 1,740 cases. Ladies and gentlemen and brothers and sisters, I now turn to another point of my speech. It is very well to say that the increased cases of jointly acquired property in the Sharia courts and the Sharia practitioners, the issues arising from jointly acquired property claims are also growing and increasingly challenging every day. This, in my humble opinion, could be a good trend for the subject of this law to expand further. Among the current issues related to harta sepencarian, that for us and for all the participants and the presenters to focus and discuss further include harta sepencarian involving Felda property, Malay reserve lands and lands under temporary occupational license TOL, harta sepencarian involving the shares of a company whose division may result in the status of a majority of the shareholders becoming a minority, the division of harta sepencarian involving properties registered in the name of the company, harta sepencarian involving the rights of non-Muslims, harta sepencarian involving properties that are still liable to third parties such as banks, harta sepencarian involving non-citizen spouse. As we know, the Land Group Settlement Areas Act 1966 restricts non-citizens from owning land. Then harta sepencarian involving non-Malay spouses. The issue may arise as the Malay Reservation Enactment contain restrictions of ownership, rentals and so on to the non-Malays. Harta sepencarian involving claim by the heirs of the deceased such as children. And finally, the status of intellectual property as harta sepencarian. أيها المستمعون والمستمعات الكرام رحمكم الله. أتحدث عن وظائف مصلحة القضاء الشرعي الماليزي GKSM. أسست مصلحة القضاء الشرعي الماليزي GKSM في عام 1998 وهي مسؤولة عن تنسيق وتنظيم جوانب القانونية والتدبيرية لجميع محاكم الشرعية في ماليزيا. فقانون الأحوال الشخصية في أكثر الولايات بماليزيا قد مرت بعملية التعديل الضخمة منذ عام 2002 لغرض التنظيم القانوني بين الولايات. ومن جانب ذلك غرضا لتنظيم القانون والتدبير المتعلق بالنزاع في الممتلكات الزوجية ما نسمي بماليزيا حتى sepencarian، أصدرت مصلحة القضاء الشرعي أوامر وقرارات المحاكم لتطبيقها في جميع محاكم الشرعية بماليزيا. وقد أصدرت 6 قرارات ما يتعلق بالممتلكات الزوجية، وذلك ما يلي: أولا، قرار محكمة رقم الثاني عام 2002 موضوع الحضانة والممتلكات الزوجية وإجراءات قانونية من جانب واحد في المحكمة العليا الشرعية. ثانيا، قرار محكمة رقم 5 عام 2003 الوقت المسموح لطلب في الممتلكات الزوجية. ثالثا قرار محكمة رقم 6 عام 2003 تعيين المحكمة المختصة في قضايا الممتلكات الزوجية. رابعا قرار محكمة رقم 6 عام 2000 تعديل لقرار محكمة رقم 2 عام 2002. خامسا قرار محكمة رقم 6 عام 2003 بتفاصيل قرار للممتلكات الزوجية في العقار. وسادسا قرار محكمة رقم 4 عام 2016 تعيين المحكمة المختصة للدعوة في القضايا المتعلقة بالممتلكات الزوجية. أصدرت GKSM قرار محكمة رقم 1 عام 2002 على جميع المحاكم لاحترام الأحكام التي صدرت من محاكم العليا، وذلك لغرض إيجاد التنظيم القانوني في القرارات والنتائج التي صدرت من محاكم الشرعية في جوانب وقضايا المتماثلة قانونيا. فكما قلت سابقا، النزاع في قضايا الممتلكات الزوجية قضية معقدة وصعبة في محاكم الشرعية. قضايا الممتلكات الزوجية هي كقضايا حضانة، تبدأ من محكمة العليا الشرعية، فالطرف المضطرب في الحكم له أن يطلب المناشدة من المحكمة الاستئناف الشرعية. بناء على التسلسل الحرمي لمحاكم الشرعية الآن، فقضايا التي تبتدئ من محاكم العليا الشرعية لها فرصة واحدة فقط لطلب المناشدة من محكمة الاستئناف. لهذا، لتقوية محاكم الشرعية بماليزيا، بدأت مصلحة القضاء الشرعي الماليزي جهود لرفع التسلسل الحرمي لمحاكم الشرعية إلى 4 درجات. إذا تحقق ذلك، فالمضطرب بحكم محكمة الاستئناف له أن يناشد المحكمة التي أعلى منها، فارتفاع التسلسل الحرمي لمحاكم الشرعية هذا قد تحقق تنفيذه في ولاية بيرك حين أسست محكمة الاستئناف الأعلى، مسمى بماليزيا محكمة أوتاما. محكمة الاستئناف الأعلى في ولاية بيرك قد بدأت جلسته في تاريخ 16 يوليو 2020 لسماع دعوى المتعلق بالممتلكات الزوجية، وهي أول سماع في مثل هذه القضية منذ نشأتها. غير ذلك، نظرا أن دعاوى الممتلكات مرتبط بجوانب قوانين أخرى كقانون العقار، قانون الشركات، فالقضاة يدربون من حين إلى آخر. مصلحة الشرع القضائي الماليزي تسعى للاهتمام في تجهيز ضباط الشريعة، خاصة قضاة الشرعيين، بمهارات ومعلومات خارجية ما تتعلق بالتدبير والمراقبة والمتابعة بقضية المتعلقة بالأموال التي tazdadu su'ubatuhu wa ta'kidatuhu yawman ba'da yawmin. Tuan-tuan dan puan-puan yang dirahmati Allah sekalian, alhamdulillah, sebagai kesimpulan, undang-undang berkaitan harta sepencarian adalah berasaskan amalan adat orang Melayu yang diiktiraf oleh hukum syarak. Adat yang diamalkan di kalangan orang Melayu sejak berkurun ini berkembang dan telah menjadi sebahagian daripada undang-undang syariah di Malaysia. Isu berkaitan harta sepencarian ini tidak statik, bahkan semakin hari semakin berkembang. Ini akan memberi peluang kepada pengamal undang-undang dan ahli akademik untuk terus membahas dan mencari solusi terbaik demi menjamin kebajikan suami, isteri dan anak-anak. Tuan-tuan dan puan-puan yang dikasihi sekalian, sekadar itu saja perkongsian daripada saya. Saya berharap agar perkongsian ini sedikit sebanyak telah memberikan buah fikiran kepada tuan-tuan dan puan-puan sekalian, khususnya peserta-peserta persidangan pada hari ini dan juga khususnya kepada pembentang-pembentang. Kita mengharapkan agar dengan pembentangan yang tajuk-tajuk yang berkait rapat dengan isu-isu yang saya bangkitkan dalam ucaptama saya pada hari ini akan dapat membuahkan hasil dan menentukan kejayaan persidangan dalam mencari solusi yang terbaik ke arah tajuk dan ke atas tajuk yang seminar ini harap untuk digarapkan dan mendapatkan hasil yang terbaik demi untuk mempertingkatkan lagi isu berkaitan dengan harta sepencarian ini. Sekali lagi saya ucapkan jutaan terima kasih kepada pihak UniSHAMS yang sudi untuk menjemput saya pada hari ini untuk memberikan ucaptama ini. Saya sudahi dengan wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi taala wabarakatuh.